we're going to talk about special types of liability. So under the law of negligence, there are special types of liability. For instance, each of the following groups is subject to slightly different rules. Manufacturers, property owners, those who occupy property, people who serve alcohol, car and pet owners, those who work materials, those who pollute an environment. These groups have a higher standard of care or subject to a wider duty of care than the average person, which means a liability means you have to go beyond the standard of care, right? That we expect you to behave or have something in a way that's far greater than the average person. It's the same way that uh, a teacher or a police officer might have a larger duty of care, right? If a police officer if I get in a fight with a police officer, or if I get verbally abusive to a police officer, they can't shoot me and punch me in the face because I got them angry. They're supposed to rate it in. As a teacher, I can't throw a kid against the wall because they've gotten me angry, right? I have to maintain a higher duty of responsibility than the average person. Okay, this is the same thing too for all these things. So, first one would be product liability, right? And it simply means the area of law that deals with negligence on the part of manufacturers, which means manufacturers must make sure the products they sell you are safe. They have to adhere to the liability, which means if they make something that you get sick from, they are liable for it. Okay, so if I made a mouse, and the chemicals in the production of the mouse, I use materials that cause cancer, I'm liable, right? Because I should have investigated if the materials that I used in the construction of the mouse would cause damage, right? So it just simply means consumers sue consumer manufacturers who fail to meet the standard. The area of law that deals with negligence on the part of manufacturers is called product liability. So in that case, it means that the design of the product is free from harmful effects. The product is properly manufactured. Consumer is informed about how to use the product safely. Consumer is warned with all risks associated with using the product, right? That's what they always do. So when you buy something, guys, you always notice that you assume that it's not, there's nothing on it. It's not jagged. It doesn't have sharp edges. It's not going to cause you to get sick. You'll get some form of instruction manual. Maybe not, doesn't mean it's always in English. It could be like a little guide that says how you're supposed to use it. You know, some you get electronic things because it X's out, don't put it in water, don't do this, don't do that, to tell you how to properly use it. Um, and any risks are warned by it, right? So if you buy electronics, it always gives you the epileptic risk that if you look at the screen, you may cause epilepsy. Does it really happen all the time? In rare cases, yes, but they have to be liable for it, right? Think about food, right? Food's is the exact same thing. You can tell what's in the food ingredients. If I say here's a box of macaroni and cheese, and you eat it and you get sick, what happen? I'm allergic to peanuts. I have to tell you on the box there are peanuts in the food, right? Nowadays, they even warn people like may contain traces of tree nuts and peanuts, right? I have two daughters; they have peanut allergies. Um, I get nervous when I see peanuts in something. I'll give it to them, but if it says may contain and there's no peanuts in the actual product, the may contain is done because what they're saying is I can't guarantee that in the production of this product, it might have come across a peanut, right? Because some of these things are manufacturers that share the same space as something else. So may contain is a liable way of saying that we don't know. You should be aware of that, right? So that's product liability, right? So you buy something, you have to make sure it's safe. Occupiers liability, the responsibility of owners or renters to ensure that no one is injured, that no one enters their premises is injured, which means you have a responsibility to make sure that someone who steps on your property does not get injured, right? So it's again says here, people who occupy a property or have a duty to maintain the property so that no one is entered, the premises is injured, which means if I have a house and it's covered in glass and you step in, I'm liable. I'm supposed to keep it free from injury. Now, the different types of people visiting having a party, there's the invitee. It's a person who has been invited onto the premise for businesses and purposes. For example, a person who delivers Your furniture is an invitee, and under common law, you owe this person the high standard of care. So I bought a exercise bike, and I want them to put it in my house and assemble it. I have to make sure the air they put it in is safe. I have to make sure that they're not injured in any way, shape, or form. I owe them the highest standard of care because I'm inviting them into my house for a business opportunity. A licensee is someone, such as a friend, who may or may not have been invited to your home for a particular reason, occasion, but has expressed or implied a permission to visit socially. So again, I still owe them a standard of care, but not as high as someone for business, right? So if Hesam pops over my house, oh, this is unexpected, right? It doesn't mean I say, oh, Hesam, come on in, just watch it for the crack pipes and the needles, right? I still have to, let me clean up. Let me make sure the area is safe. Right? I still owe them a standard of care, but not like a person who comes in your house to work or for business. Last person is a trespasser, someone who has no legal right or permission to be on your property. Burglars, stalkers, vandals are examples of trespassers. Now, the weird thing is trespassers still have some, which is weird, someone trespasses on my property, I still owe them a standard of care, right? I think everyone has always heard those stories of criminals and like the cases where someone breaks into their house and robs them, they gets injured, and they sue the house because they're saying the house was dirty and I got injured. So again, I don't know if that's the case, but the idea is if someone enters, you've got to keep a level of protection, cleanliness, safety within your area, right? You can't have sharp things in your lawn, even if someone trespasses, right? The law treats children who trespass differently than adults who trespass. The courts acknowledge that children who are easily attracted to such sites such as swimming pools or playgrounds, any item that might entice a child known as an allurement. Occupiers must keep all reasonable precautions to protect children who could be lured to their premises. Owners of swimming pools, for example, usually surround their pools by high fences. So kids are even treated differently, right? Thomas, well, not Thomas is a little kid, but let's say Thomas is 11 years old and he sees a pool, he might go jump on it. If he sees a slide, he say, oh, I want to go there. It's a trampoline, I may use it. We have to, people who own those things have to ensure that those kids don't come, because children don't necessarily think or fall through with other actions, right? They just see, oh, it's a pool, it's hot, let me go, just go jump in the pool. So they put a fencing around it, right? Oh, look, there's a slide. Let's go look. That's why you don't have it clean. It doesn't have any jagged edges or sharp edges, right? The trampoline. Most times, not people who have trampolines, if you notice, they have a fencing or a net around the trampoline. Okay, so these are things that you need to do for trespassing. Vicarious liability is the legal responsibility for negligence for the negligence of another person. So it's all this appears in the workplace where employers can be held responsible for the actions of their employees, right? So it says here about vicarious, but I want to talk about here as a teacher, right? The school is held responsible for the actions of my negligence, right? So teachers are all given, we have duties and we have responsibilities, right? I am not supposed to just say, hey, I'm tired, I want to get a coffee, I'm gonna run up to Starbucks, I'll be back, right? If I do that, and let's say Virginia gets injured, I'm liable, but also Willowwood's liable because they hired me and they're supposed to train me to be in areas of safety. And if I don't follow the thing, they're liable. That's why lots of times in staff meetings, we sometimes get into very heated debates and not debates, but Fred will come down and Andy will also come down and say, look, you need to be at your duty, right? If I have an outside duty, I'll say, guys, we're leaving early, right? Because if I'm not there on time, the school's responsible, right? So not only do I get sued, the school gets sued as well because I'm supposed to be there on time. So if you own a business, you're responsible for the people there. If they're negligent, you've got to deal with them, right? So sometimes that's why sometimes people get fired because you were negligent. You caused problems. You didn't do what I asked you to do. You didn't follow the procedures. I hold you responsible.
So
Yeah.
have there actually have been cases involving teachers suddenly leaving the classroom? like go get buy something?
So I am a member of the College of Teachers, and it's a professional. Basically, it's a professional organization that's supposed to monitor teachers so they behave themselves. Now, it gives you a bunch of magazines about all the things teachers are doing. Yeah, yeah, yeah. It's great. At the back, there's something called the Blue Pages, which tells people about when teachers don't do their jobs. It can be anything from a teacher selling drugs in their classroom to teachers grooming their students for relationships to negligence like that. So, yeah, there have been teachers who have lost their jobs because they were negligent. There have been schools who have been sued. Think of the C.W. Jeffries thing, right? With the kids who got drowned on a camping trip. The school's responsible because they said those kids had passed a swim test. They did not. The teachers didn't follow through on, hey, did you all pass the swim test? Which meant the school, the principal, the administration, everyone responsible for the deaths of those kids. Right. So yes, that happens all the time. In fact, it happened so badly a couple years ago that insurance rates for private schools went through the roof. We were told what we could and could not do. Uh, I think some of you guys played sports. Do you guys notice that when we played sports, all of a sudden we couldn't drive you anymore? It was a liability issue. We couldn't drive you in our cars. We couldn't do certain things without permission. We couldn't uh, uh, have events at certain times. I mean, it got so bad. Like, I remember talking to Andrew about the camping trip, and he was getting very nervous because he was like, if I don't have, I think they got rid of swimming because they said, if I don't have everyone taking the test and they go swimming, I'm liable. So I think even camping, they stopped swimming because they didn't want anyone to get injured. Because our insurance company was telling us you have to do this, and this. Right. So it did happen, and it does cause and because we can't function without insurance, which means we can't function if something does happen that we can pay people. Um, we get hampered by that and we have to pay very high rates, uh, and we have very strict rules about what we can and can't do. Right. Like our duties even switched because the insurance people came in. You need someone over there, 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 you need these people, and we had to adjust because we're held liable, and the schools held liable through vicarious liability. Okay, so automobile negligence, guys, this is probably something that you're all going to have to deal with because you're all going to want to drive a car. So many torts resulting from our car accidents and numbers of different branches of law may be involved in a single accident. For instance, a driver responsible for may be charged with a criminal act, fined for an infraction of a provincial motor vehicle legislation, and sued in civil court. Every province or territory has its legislation for a number of regulations for owners of motor vehicles. This legislation imposes vicarious liability to the owners liable for damages as a result of any negligent behavior or anyone who drives the owner's car. So, having said that, Nate borrows my car, he smashes my car into someone else, I'm responsible for paying that person's car, right? Because it's my car that I lent to him, right? So I think the idea is the insurance doesn't travel with the person, it travels with the car, right? That's why for a while teachers could drive students because the school would give the teachers $1 million of insurance in case something goes wrong, right? Uh, if I lend my car to someone else, I'm ultimately going to be responsible for it, right? As learned in Chapter 13, vehicle owners are required to carry a liability insurance. However, a defendant may still have to pay for any damages insurance costs. So again, I have to carry liability insurance, right? So when I own a car, I have to pay for what insurance that says if I injure someone, if I cause damage, I'll be paid for it. Sometimes the insurance may be, when it comes to car accidents, there's something called deductible. So it means if I get into an accident and my insurance covers Ryan's car, I'm going to pay a certain amount before the insurance kicks in. So it may say, we'll cover you for $1 million, but you have to pay the first $1,000 or whatever, 250, whatever it is, right? If we don't have insurance, it's hefty fines. It's illegal to drive without insurance, right? You'll be fined because again, if I'm in a car, I get hit by a car and I have to repair my car, right? The person who hit me needs to be able to give me the money. If they say I have no insurance, I have to then sue them, right? And it's harder to get money to pay for stuff, which means I have to pay for the repair costs out of my own pocket and hope that I'm able to recover the damage from someone who doesn't have insurance. If you don't have insurance, you probably don't really have a lot of money, right? People who drive without insurance, are reckless, and therefore, I don't know if they have money to cover the cost of a car they hit. The next one is called strict liability, which is the defendant is automatically liable for injury caused by a dangerous active substance or activity, even if the defendant was not negligent, which means that you are responsible for anything that happens to a person, even if you did nothing wrong, right? This usually happens with environmental laws, which means even if the agent, so let's say a company is dealing with toxic waste, right? Even if I've done everything right, even if I followed all the procedures, even if I made sure that everything was safe and someone got sick, I'm still liable. The idea is because these things are so dangerous that you must adhere to the responsibility whether you've done something or not. So let me just read the example from the book here. Several provinces have introduced legislation that attempts to impose strict liability on dog owners. In some cases, owners may be liable even if their dog has never bitten anyone before. In fact, the plaintiff may not have to prove that the defendant owed a duty of care. On the other hand, some other statutes being strictly liable for a dog's behavior does not mean the owner will be 100% liable. Dog owners may be able to argue certain duty of protective care cause injuries. Your defense, you can prove the evidence to show that you do not owe duty of care. You've met the standard of care. So for certain things, like some people think that if you have a dog, you should have strict liability because your dog bites somebody, you're responsible for it, right? But it's usually for environmental law, right? Anything that deals with the environment, anything that's of grave nature that could cause devastation to society, there's strict liability attached to it. So you always are responsible. Even if you did everything right, you're still responsible. Okay. Contributory negligence, negligent acts by the plaintiff that helped cause the plaintiff's injuries. So this is again, if Regina goes skiing and she gets injured, and I go over, I go, oh, you're fine, Regina. And I try to help her up, and I go, let me just pull your leg, you'll be fine. Now the injury, she can sue the ski hill because she was on the bunny hill and they didn't take care of it, so she got injured. However, I'm also negligent because what I did was not get her aid. I just tried to help her. I pulled her leg. So maybe I'm 25% of the injury, contributory negligence versus the 75. So sometimes if your acts lead or help to make the situation worse, you are liable. So again, it says here, here's an example here. Suppose you're skiing, you stop to take a rest on the hill. The skier sees you at the last minute but is unable to stop. The skier crashes into you, breaking your leg and your skis. You sue the skier for damages. The court might determine that you contributed to the accident by stopping where it was difficult for the other skier to see you. The courts could also apportion the blame and declare that you were 25% responsible for the accident and the defendant was 75% responsible for the skiing too fast in the areas. So not only does it can be divided, but also it can be a situation where you might have some blame in it as well, right? If I stand in the middle of the road having a donut and I get hit by a car, the driver's still responsible, but why am I in the middle of the road? So I owe some duty of care. However, if I was walking across the street on a green light and the driver hits me, they're responsible 100%, right? So if you did something that put you in some form of danger, you might have less, the liability may be a little less than, let's say, someone who you did nothing wrong and something happens to you. So other things I want to talk about are voluntary assumption of risk. This happens a lot with sports, right? So this means that a defense that no liability exists because plaintiffs agree to accept the risk normally associated with the activity. So think about sports, right? If I played hockey or football or any other contact sport, I assume an assumption of risk. However, I don't assume all of the assumption of risk. And there was years ago, there was a hockey player who, can't remember his name, Brochure. The guy hit him in the back of his neck and he knocked him out. And the guy I think went to a coma or had a concussion. Now, people argue that in hockey, because there's contact, you assume risk. However, he didn't assume the risk of that guy using a hockey stick to hit me in the back of my head. I'm not assuming that risk, right? In hockey, I assume that I'll get checked. In hockey, I'll assume that I may have to drop my gloves and fight. I do not assume someone using a hockey stick as a weapon. And the case was that people are suing him that the NHL couldn't say, well, it's fine, it's hockey. He goes, no, no, no. It's not hockey when another player takes it like as a weapon and uses it against you. That's not what I agreed to, right? I assumed risk, but not a risk. In football, I hit somebody, we play, you fall, I got injured, I assume that risk. But if that player then over, as I'm on the ground, walks over, kicks me in the gut and stamps on my hand and puts a hole in my hand, I don't assume that risk if it was something violence, right? Now, when people participate in those things, they sign a waiver. It's a document from the plan releasing the defendants from liable in the event of an injury, right? So you notice if everyone's played sports here, you sign a waiver. If you play sports someplace else, you sign a waiver, right? It's just saying, you can't sue the school if you're injured, right? Because again, while you assume a certain number of risks, you do not assume all of it. And you do not assume something that's beyond the scope of the game. Play basketball, throw up, try to get a rebound. I hit somebody, we both fall in, hit my shoulder, hit against the wall, I'm injured. I have to assume that risk, right? However, if in the middle of a street field, somebody walks up and hits me in the back of my head, I did not assume that risk, they're liable. So there are also defenses to this, and you'll know this for the next assignment. So basically, anything with liability, there are some defenses. There's never an accident. The defense claims that the accident was unavoidable due to an uncontrollable event. So think about a roller coaster. It's been checked out. It's safe. You're rolling it. All of a sudden, boom, something happens beyond your control, and it falls apart, right? So someone just got driving on a country road, and a bee flies through her open window and stings her. She loses control of the vehicle and hits the oncoming car. If Jessica sued for negligence, she could argue that the bee accident was inevitable result of being stung by the bee. So again, you're doing everything right, and something comes at you. A bee stings you in the eye. You grab your eye, lose control of your car, you hit somebody. It's an inevitable accident. It's going to happen. This act of God, the claim that the accident was caused by extraordinary, unexpected natural events, as a tornado, earthquake, or flood. So there's this act of God. It appears on the insurance a lot. Sometimes you have insurance and people want to protect their property. There's sometimes a called act of God, which means insurances will not cover a tornado, right? I can't control a tornado, so I won't give you insurance for it, right? Especially if tornadoes in an area that doesn't exist. Now, the difficulty, if you live in an area where these certain types of environmental effects happen, insurance is hard to get. Like if you live in California, I don't think you get fire insurance because there are wildfires there, right? And it's seasonal. If you lived in New Orleans, flooding happens because you live in a basin, right? So depending on where you are, act of God becomes a situation where you say, well, you can't sue me. This is a result of God, right? However, if all of a sudden a tornado hits Toronto here and hits Willowwood and we all get messed up, the chances of Toronto having a tornado are slim. It's an act of God, right? It's not really predictable, right? Have there been tornadoes in Toronto? Yeah, but not as much as that you could say this is something that happens all the time. The next one is explanation. The defense claiming that the accident occurred for a valid reason, even though the default took every precaution, which means the person explains that I took every precaution to prevent the accident from happening, but it happens anyway. And if the situation does not include strict liability, I can claim I'm fine. So if, again, I spilled the water on the thing, as I spilled water on the thing for the gym, but what I did was I put signs around it saying, don't step here. I told all the kids, I spilled water, please don't go into the gym. I'm waiting for someone to get a mop so I can clean it up, right? Yet someone runs past me and runs into the area I told them to go, and I cordoned it off, and they slip and fall. I could say, look, I've done everything possible to avoid this accident. Yet the person still disobeyed what I said and did what they wanted. I can explain my way out of the defense. That's when the statute of limitations, which means the law gives specific time in which illegal action may be taken. So some laws have a certain amount of time where you have to file a complaint, right? 2 to 5 years, you have to. So it could be if Ryan gets injured in a sporting accident, he has 1 to 3 years to sue me. If he waits 10 years, he can't. So there are sometimes limitations on it because, again, they want to be able to say, this act caused your injury. And if you say, I still have a problem with my shoulder 10 years later because of an injury, I'm like, well, I don't know if that's true. It's too far away from the actual act for me to connect it. So statute of limitations is supposed to get people to, one, connect the act to what's going on. And 2, it helps not overcloud the system where we have tons of cases that never get resolved because people are suing 10, 15 years later for something that happened 10, 15 years ago. Okay?
So you can't sue someone for something that they did like 10 years ago.
It depends if there's a statute of limitations, right? So if there's a limit to the amount of time when you have to bring a charge as defendant, if you're applying for a civil action, you need to do it within a certain amount of time, right? Law also has that for criminal law, but certain things don't have statute of limitations. Like I think murder doesn't have one. But for civil law, they probably do it because it get ridiculous. Think about it. People would sue all the time, and then you grind to a halt. You've got to have causation settled quickly. Okay, so that's all for that section. So everyone gets the idea of liability. It just means that it's a higher standard of care that certain organizations have. And again, the big 5, big 6 are occupiers liability, where you live or you rent, you're responsible. Vicarious liability, your employees are responsible for what's going on. Host, if you're hosting something, if I let people come to my house, I am responsible for them. I'm negligent, you own a car, have to have insurance, got to be able to pay for injuries or medical conditions if you hit somebody. Trip liability, that means you must, even if you've done everything right, you are still responsible for any injury or damage to your situation, and that usually is for people who deal with deal with dangerous chemicals that could impact our environment. Product liability, you buy something, it should be safe and not dangerous, and you should have instructions how to assemble it and make sure how it's going, and also make sure that it's not going to cause you damage, and it works. Okay, so those are the big 6 for special liabilities. Any questions? Okay, I think I'm gonna put this on the board, but what you're gonna do is read the pages that we have here, which is 425 to 425 to where's it? Page 432, and answer questions 1 to 5 on page 134. Now I might have said you have to read up to 134. Don't read the cases; they're just examples of that. If you want to, go right ahead and knock yourself out. But those are just examples of cases of that. Here's one about African lion safari. And that's the one about someone lowering the windows and animals coming in. I remember when I went with a bunch of kids for a trip, they did lower the windows a bit and the monkeys try to get into this the bus, but the kids actually attacked the monkey. It was really funny. But, is African lion safaris responsible for, making sure everyone's safe in a car? Do they have strict liability? Because again, those are animals, and they will react like animals, right? Tigers will attack you, not because they're crazy, because they're tigers and they're predators, and they will come at you, right? Are they responsible because they have to make sure, even the other thing? Or if you open the window to the ape pavilion or orangutan pavilion, are you responsible? Because monkeys and apes are strong and they can rip off your arm, right? Right? I remember there were kids who, this kid I went to school, well, not school with, but this kid who I knew in the neighborhood when I was going to school in Scarborough lost his arm because he climbed the fence at the zoo into the tiger cage, and the tigers went nuts and he took off his arm, right? Now, did he try, was it the zoo's fault? I don't know. I didn't. The zoos have cages and they tell you not to do so. Having said that, every years ago, I remember going to the zoo, seeing, what's it, the convenience section or like a food court, and you could buy beer and wine there. And across the way where there was a pavilion for giraffes with fences that you can climb. And I thought, that's dangerous. That's stupid. What if I get drunk and figure I want to ride a giraffe, right? I joke with my friend, goes, doesn't anyone see the liability here? Like, does anyone see that's a bad idea to put beer in walk-ins of giraffe encampment where the fence is only 6 feet, which means you can climb it pretty easily? Who knows? Okay, I'm going to stop the recording.